Last week was our first playoff game, and my plaque psoriasis was so itchy under all my gear. Sometimes just thinking about scratching could take me out of the moment. And then my doctor told me I could get clearer skin with a pill called Otezla.
Otezla apremilast is a prescription medicine used to treat adult patients with plaque psoriasis for whom phototherapy or systemic therapy is appropriate. Otezla can help you get clearer skin after just 4 months.
Okay, ready for the next game. Talking to my doctor about a pill was a total game changer.
Don't use Otezla if you're allergic to it. Get medical help right away if you have trouble breathing or swallowing, swelling of the face, lips, tongue, throat, or arms. Severe diarrhea, nausea or vomiting, depression, suicidal thoughts, or weight loss can happen. Tell your doctor if any of these occur and if you have a history of depression or suicidal thoughts. Live in the moment. Ask your doctor about Otezla. Call 1-844-4-OTEZLA or visit Otezla.com for prescribing info about cost, and more.
It's the Roger Stone Show on 77 WABC.
Welcome back, folks. I'm Roger Stone, and this is the Roger Stone Show. Joining us now is a man who has been tormented by the deep state, perhaps as badly as what they did to General Michael Flynn, what they did to Paul Manafort, what they did to me, what they did to George Papadopoulos, what they're really trying to do to Mayor Rudy Giuliani. Jeff Clark was appointed by President Trump as Assistant Attorney General with oversight of 2 of DOJ's litigating divisions. He is a Harvard and Georgetown educated attorney. He is also the director of litigation for the Center for Renewing America in Washington, D.C., which is a MAGA think tank. They have sought to disbar and destroy Jeff Clark because he had a different legal opinion of those deep staters above him, such as Attorney General Bill Barr and then Acting Attorney General Rosen. Jeff Clark, welcome to the Roger Stone Show.
Hi, Roger. Great to be here. Thanks for having me on.
I'm honored to have you with us. So, look, nobody can tell this story better than you can. At one point, it was thought that you might be appointed acting attorney general. That didn't happen when there was an uprising in the department. I found it interesting. The argument against you was you hadn't actually been in court. Guess what? Bobby Kennedy was Attorney General of the United States. He'd never been in court, never tried a case in his life, and knew a lot less about the law than you ever knew, Jeff. So start from the beginning for my listeners, and let's unwind why you are being persecuted even today.
Hey, Roger. So two quick corrections. Actually, I was the acting attorney general.
I apologize.
Only for 9 hours.
I see.
Yeah, only for 9 hours.
Wow. That is,
So
I was unaware of that.
Yeah, on January 3rd, in the morning, I was named by President Trump the acting attorney general, and then the uprising you referred to occurred after that, and then that decision was reversed in late the evening of the same day.
Go ahead. I'm sorry.
Go ahead. Yeah, I mean, had I taken over, I would have investigated the 2020 election with a lot more energy than those who were in charge of the department before and after.
I apologize and stand corrected. You know, the great Christian prophet Kim Clement, a man who was South African, but who was a prophet, saw many things, actually has a prophecy, which many evangelical Christians tell me is about me, where he says the giant will be taken down by a simple stone, the giant being the deep state. He says, will be taken down by a simple stone. He says, remember that name. Now, I'm a Catholic. I'm a believer. I respect his prophecies because he also predicted the election of a man named Donald. He says that there's a second man, he says, who will save the Constitution, and his name is Clark. So, Jeff Clark, you may indeed be that man.
Well, Roger, I don't know how to react to that. There was another person or two who told me about that statement, and I did see a video on YouTube about that. But I can't focus on that. I think I have to focus on, the situation I'm in, which is a dire one, as you described. They're still trying to strip me of my law license, and they're still prosecuting me down in Georgia. Luckily, down in Georgia, they have stayed that case, the Georgia Intermediate Court of Appeals, because we had filed to disqualify Fani Willis after Judge McAfee's decision allowing her to stay on the case as long as either her or her lover, Nathan Wade, had taken himself off the case. So, of course, Nathan Wade, the inferior picked by Fani Willis, is the one who went, leaving her to go forward, which we think is legal error. In fact, tomorrow we're filing a brief on that subject, and then the court is going to hear oral argument in October. So thankfully that case is on ice for a while, but it's not like Fani Willis is giving up on it. I think she's going to have to be removed from that case kicking and screaming, even though we think that that's the legal outcome that's demanded under Georgia law.
Look, I want to make myself clear. I'm not claiming to be a savior or a prophet or certainly a saint. All I'm saying is, Jeff, when I say my rosary at the end of every day, you are among those that I am praying for. His will be done. You have been a real fighter. You have really gone toe-to-toe with the Office of Disciplinary Counsel that is seeking to disbar you. What act is it that they claim merits this treatment?
So they have accused me of two things, Roger. One is that I attempted to lie, which we really can't find any prior bar disciplinary cases using that theory before. And then the second one is that I prejudiced the administration of justice by proposing to send a letter to Georgia, the Georgia legislature. So on the second one, that one should really be easily dispatched because there are a set of requirements that the D.C. Court of Appeals, the highest local court in D.C. under home rule, has established for that kind of theory, and it requires saying something to a court. And in this instance, I didn't say anything to a court, and indeed the letter never left the department. It was a draft letter, and it was not presented to any government agency, let alone a court. So back on the theory of attempted lying, the theory basically is trying to make unlawful, make unethical the idea that you disagree with others at the Justice Department. So the theory is that the Justice Department, this disembodied entity, investigated the 2020 election. They found no sufficient fraud, and that's very carefully defined that way, to change the outcome of the election. And therefore, since the draft letter that would have gone to the Georgia legislature had it been approved, indicated that the Justice Department had suspicions about fraud, not just fraud, but irregularities in the 2020 election, meant that I was trying to lie to the people at the department who had done the investigations. It's a theory that doesn't make any sense because they're the ones who had done the investigations. And I'd asked to see the investigations, and the testimony at the trial that wrapped up against me in April, they admitted that they didn't show me the investigative files, and they refused to explain why they would not show me the investigative files. And in recent briefing I filed, I argued that, well, that gives rise to an inference that the investigative files didn't show what they purport to have them show. In any event, the letter was a proposal. And so, people, lawyers, other people, they disagree with each other all the time inside the Justice Department. I can tell you that from experience that goes back to 2001 of being at the highest levels of the Justice Department. And we know that the Supreme Court itself, right, has lawyers on it, justices on it who disagree with each other. That's why there are dissents. That's why there are concurrences and other kinds of statements, because reasonable minds can differ. So how can it possibly be unethical to propose something different than your then superiors think? It's not. And it's essentially trying to create a kind of thought crime.
I'm obviously not an attorney. I'm not completely familiar with the Electoral College Act. The mainstream media and the Democrats, partisan prosecutors, have made much of what they kept calling fake electors. But I have read that an alternative slate of electors was filed by John F. Kennedy in Alaska in 1960. And that it was thought on election night that Vice President Richard Nixon had taken the state. Nixon filed his slate of electors on the basis of absentee ballots. John Kennedy ultimately prevailed, and his alternative delegate slate that he had filed became the certified electors for Alaska. So the idea of alternative electors, who, in the case of Georgia, I remember reading the minutes where they said, we are taking this action to preserve our rights pending our lawsuit, which I think shows good faith. There's also a case in federal court that, surprisingly enough, a Democrat judge, Judge Totenberg, has been presiding on, which I think really questions some of the fundamental questions over the conclusion that Georgia was won by Joe Biden. Am I wrong about that?
No, you're right about both of those things, Roger. And the draft letter to Georgia actually laid out the history of the Nixon-Kennedy election with the alternate electors in Hawaii who ultimately became the actual electors, right? So it's not true that alternate electors are either automatically illegal or that they can never be converted into actual electors. That's all up to, a multi-stage process, right? There's a first thing, people need to understand, right, is that there are usually executive branch authorities inside the states that certify who wins an election, but courts can alter that, right? That's what litigation's about. Second, the Supreme Court has said, going back a long time, that the state legislatures have plenary power over who their electors are. So the state legislatures could reconsider the electors that otherwise emerged from the process. And then third, the January 6th process, using the Electoral Count Act in place at the time, and it's a different one than exists now because the January 6th committee pioneered revising that statute. But the one, certainly in effect in 2020 would have allowed Congress to decide whether to certify the electors that were coming from the state. So there are multiple stages where all of this was contested. And so, yes, you're right about that. And you're also right about this still pending litigation in Georgia in federal court in front of Nina Totenberg's sister, Judge Totenberg down there, called Curling v. Raffensperger. It's still pending, and it has an expert witness in it who's a University of Michigan computer scientist, and he specifically, showed the judge that he could hack into these computerized machines in minutes. And indeed, this is something that I don't think I've spoken about a lot, so it'll be new for your program. But in 2019, the D.C. Circuit, right, which many folks often say, even though it's not entirely technically accurate, that it's the second highest court in the nation. The D.C. Circuit sits in D.C. It reviews all sorts of cases about federal administrative agencies. It obviously has jurisdiction over federal crimes committed in the district or other things brought to it. And many of its judges go on to serve as justices on the U.S. Supreme Court. So that court held its annual judicial conference in 2019 out in Cambridge, Maryland, on the Eastern Shore, which I attended at the invitation of the court. And the name of the conference for that year was Cyber Everything. And it brought this professor, Professor Halderman, out. He was on a panel, and he talked about how the electronic machines were not secure. And the judges, lapped that up because the focus in 2019 was looking backward to the 2016 election and the arguments that were being made by our, much vaunted, but I think, highly questionable intelligence community that the Russians had stolen the 2016 election for Donald Trump, right? So it was one thing for the judges to sit in a lecture and hear about electronic voting machine insecurity and hacking and the fact that they don't meet their own standards under federal law. They lapped that up then. But then if you fast forward to 2020 when President Trump and others were questioning use of the machines, then magically, the machines are perfect. So it's quite the contrast. And obviously, I knew about that 2019 conference. I knew about Professor Haldeman's work because I had attended the conference, and that was one of the things that was in my mind at the time I was working inside the Justice Department and questioning the conclusions others were coming to about the 2020 election.
And that is pending litigation. I have to fully disclose that Nina Totenberg was my next door neighbor when my wife and I lived in Washington, and although we shared no politics, she was a very pleasant lady who loved a good martini. She was married to Floyd Haskell, was the U.S. Senator from the state of Colorado. I don't know much about her sister, the judge, but so far she seems to be handling this case in a very unbiased and orderly manner. It's very, very interesting. What is your opinion of this issue that has been filed with the court in Florida, questioning whether special counsel was constitutionally and legally appointed?
So, Roger, I think that these special counsels are unconstitutional. And I think this goes back to the whole issue of whether independent counsels were constitutional or not. The Supreme Court ruled 8-1 that they were in a case that involved Ted Olson, Morrison v. Olson. And, it's sort of like what's old is new again. So back in the Reagan administration, this ties to Justice Gorsuch, right? Justice Gorsuch's mother, and Burford Gorsuch, is the EPA administrator, and the Democrats really hated her because she was trying to deregulate and bring law and order to EPA. And so John Dingell, the congressman, went after her, and they had fights about what documents to turn over, and we're obviously seeing lots of document fights going on in the current era as well, and we saw them in the Trump administration too. And so ultimately, Ted Olson was in charge when he was the head of OLC of rendering some opinions about, what documents should be turned over, and he refused, and, that led to the appointment of an independent counsel, this woman, Alexia Morrison, and that caused Ted Olson to challenge the constitutionality of the independent counsel, which was set up by statute. There was a lone dissenter in that case, Roger. That was Justice Scalia. And he explained that it is unconstitutional and makes no sense, really, to have a prosecutor who doesn't have a generic multi-defendant, potential defendant docket, but instead is focused on getting one man. That makes the person into an inspector javert. It's not the U.S. system. And he set out all the reasons why it violated the separation of powers. Now, at the time, many thought that, this was just idiosyncratic Scalia. But those of us who love the Constitution always thought that his dissent had the better of the matter. Indeed, I've seen interviews with Justice Kagan, right, who is no, conservative like a Thomas or a Scalia or a Gorsuch or an Alito, saying that, that dissent has really stood the test of time. She refused to say that she agreed with it, but she did say it came out a year she was clerking on the court, and that she thought that, Justice Scalia was crazy at the time, but over time she realized that many of his criticisms directed at the statute were true. And I think the main pivot point for the left on that issue was the fact that Ken Starr was appointed as independent counsel, one of my mentors at my private law firm, Kirkland & Ellis. Sadly, we've lost Ken, but he pursued President Clinton, and once the ox was gored on the other side, that caused a sort of bipartisan groundswell to not re-up that statute because it had a sunset date. So what did the Clinton administration do under Janet Reno and then Neil Katyal, who at later time was an acting Solicitor General? They wrote regulations to try to replicate as near as they could the independent counsel system using regulations that were issued by the Attorney General. And that's our current status quo. We live under that system. So Robert Mueller, Durham, and now Jack Smith were all appointed under the authority of these regulations.
Of course.
Now, I think that
Jeff, I'm going to stop you there. We're going to go to a quick break. We're talking to Jeff Clark, former acting Attorney General of the United States, and this is the Roger Stone Show. Don't touch that dial, folks. We'll be right back.
It's the Roger Stone Show on 77 WABC. It's the Roger Stone Show on 77 WABC.
And we're back, folks. We're talking to Jeff Clark, former acting Attorney General of the United States under Donald Trump, a man of enormous courage and great legal knowledge, who is really, I think, in the crosshairs of the deep state because they don't want to see Jeff Clark in another Trump administration. So they seek to take away his status as a lawyer at the bar, which would be a national tragedy because this could be a slogan: Jeff Clark did nothing wrong. We were just talking about the challenge that has been filed in the Florida case where Judge Eileen Cannon has scheduled several days of hearings around the question of whether the special counsel, Jack Smith, was constitutionally appointed and whether the funding of his investigation is constitutional. The argument there, of course, is that he was not ever confirmed by the Senate. Robert Hur was a sitting U.S. attorney. Mr. Weiss, who investigated Joe Biden, a sitting U.S. attorney, both therefore already confirmed by the U.S. Senate. It's interesting. Gary Fineout, good reporter, with Politico, wrote about the challenge mounted in Florida. Other courts have uniformly swept aside similar challenges to the validity of special counsel appointments. Other than the Andrew Miller case, in my case, where Andrew Miller, a young staffer who worked for me, did not want to testify, he filed an objection. The trial judge, Amy Berman Jackson, of course, swept it away. The D.C. Court of Appeals, or the Court of Appeals for the D.C. Circuit, affirmed. I think that's called wrongly decided. It never got to the Supreme Court because, well, poor Mr. Miller would have to sit in jail while he waited for that. In the end, the Mueller prosecutors never called him anyway because he had nothing interesting to say regarding Roger Stone or my case. So I think it's interesting the way Jeff, the left, despite this terrific amicus brief by Ed Meese, a man I've known since 1979, and admire, two very respected law school professors who are not like you and I, conservative Republicans. But the left just kind of wipes this away as being frivolous, ridiculous, absurd. What's your take on that?
Sure. So first, let me say, Ed Meese is great. He's a national treasure, and he actually was one of the witnesses who testified on my behalf about how none of this made any sense under federal law, the effort to go after me in my bar trial. And he's down trying to help President Trump in Florida, along with, as you say, some law professors who are not exactly always Trumpers, let's put it that way, probably quite the opposite, as you say. So, look, I think the legal theory that's been presented is great. First of all, I think the most aggressive theory is that Justice Scalia was right all along, going back to the independent counsel statute, and any attempt to appoint an official at the Justice Department who wields powers, who is not subject to the president's authority and serves, at their pleasure, if they're going to wield principal officer type authority like a special counsel would, is unconstitutional. But even if there's a lesser argument that under which this the special counsels can't constitutionally serve, which is the one that you just pointed out about the fact that Jack Smith is not Senate confirmed. So all of the U.S. attorneys, with some exceptions where there are vacancies and the like, are appointed by the President of the United States and confirmed by the Senate. All of the U.S. attorneys have limited geographic jurisdictions, right? So there's one for the Southern District of Florida, there's one for the Southern District of New York, there's one for D.C., but, they don't go roaming across the entire country. The Attorney General can roam across the entire country, right? But, of course, he's Senate confirmed. So what they did by this regulation is they created a kind of super U.S. attorney, or as I've called it on Twitter, like Shazam, because Shazam combined the powers of like a whole bunch of Greek gods, right? Like he's strong like Hercules, and he's fast like Mercury, et cetera, right? And so this official Jack Smith, right? He combines all the powers of the U.S. attorneys, and yet he's not Senate confirmed. And under the regulations, he can't be removed by the president, and he cannot be removed by the attorney general except for cause. And I think that that's an unconstitutional system because it takes, someone outside the chain of command back to the president. Now, interestingly enough, after I pointed all this out on Twitter, Lawrence Tribe, the Harvard law professor, suddenly surfaces and he says, well, the regulations are discretionary and they can be eliminated by the attorney general, and then and the president could tell him to eliminate the regulations, and so therefore the whole system is kosher, right? But this is them talking out of both sides of their mouths, Roger, because how often did we hear that Jack Smith is independent? He's independent. When Trump says that Jack Smith's been weaponized to go after Trump and take him out by Joe Biden, that's not correct because he's actually independent of Joe Biden. Okay, but magically now, after I started pointing out how this makes no sense, how Meese and Federal Society affiliated law professors have pointed that out down in Florida, and Judge Cannon's questioning it too. Oh, now magically he's not independent. He actually does trace back to the president. So they realize they have a problem here, Roger, and they can't have their cake and eat it too about it.
That's why I'm convinced that this fabrication, taking things that I said on a illegally recorded video that I say in speeches every week around the country, nothing improper, that Republicans need to use every legal and technical tool necessary to make sure, using my exact words, we have an honest election. And yes, the party lawyer should have access to the courts in case it becomes an emergency. We saw it graphically in the counting center in Detroit, as I said earlier on the show, when Democratic observers had Republican observers physically removed by the Detroit police. Those are the kind of authoritarian tactics that cannot be allowed, but can really, the only relief you could get would be in an emergency appeal to the courts. And then they try to say, because it was my opinion, just because I read the all of the filings in the documents case, and also relied heavily on the terrific reporting of Julie Kelly, that I thought it was possible, maybe even likely, that Judge Cannon was going to dismiss the charges against the president, something I turned out to be incorrect about, because a specific motion was made to do that, kind of proving yet again that I have no particular insights. It's based on my opinion. But to say that I implied that the judge was in Trump's pocket, I said nothing of the kind.
So I saw that, right? I've watched this whole Lauren Windsor thing, and Lauren Windsor's also tried to be a thorn in my side. She showed up outside my workplace one day when me and several of my teammates were headed to lunch, and she fumbled her camera and actually pointed it in the wrong direction and got mocked on Twitter for that. So she was determined to do a better job. She showed up for the first day of my bar trial and then, just tried to ambush me with, silly questions and ones attacking me personally. We just ignored her and got in the car and drove off. But she's a problem. And I saw that, you had said to her that one of the things, in addition to a whole laundry list of options that and tools that have no legal problems whatsoever, that, there had been advanced preparation of getting judge home numbers. Now, the way MSNBC spins that is, well, that's improper. What they're saying is that they have judges in their pockets in advance. Like, no, that's not what you were saying. To any lawyer who, has any modicum of experience, they know that's not what you were saying. And look, for emergency motions and the like, sometimes you're going to find that the court is closed, right? It's closed on evenings. It's closed on the weekends. It's closed on holidays. And if you need immediate relief, sometimes the only way you can try to do it is to track down a judge at home. I can tell you there's a famous case where J. Skelly Wright, a liberal judge of the D.C. Circuit, which I'd mentioned, he was tracked down at home and then, gave emergency relief. I can tell you that when I was clerking, the very first dinner I had with the judge and his wife, along with my co-clerks, back in 1995, the phone rang, and it was a lawyer who had reached my judge, Judge Boggs, to ask him for emergency relief because what was being threatened was a violation of the prior restraint doctrine. Like there was a district court judge who had ordered the press, not to put out a story, which is a serious violation of the First Amendment, right? So, there was nothing nefarious going on. It wasn't like one of the judge's buddies or a political operative or campaign member or something was calling the judge at home to fix something. It was just that's the only way sometimes you can get emergency relief where every minute counts.
That's precisely the point, of course, that I was making. All right, unfortunately, we are out of time. Jeff Clark, a great patriotic American, former acting Attorney General of the United States. Jeff, your legal bills have to be astronomical. Where can folks go if they want to help you?
Well, thank you, Roger. I appreciate that, and I appreciate your prayers as well. You telling me about that, and my family appreciates it. So I have a Give, Send, Go set up at www.givesendgo.com/Jeff Clark, just JEFFCLARK.
All right, many thanks, Jeff Clark. Thank you for joining us today on The Roger Stone Show. Folks, don't touch that dial. We'll be right back.
It's The Roger Stone Show on 77 WABC.
Plan on flying? It's time to upgrade to a Real ID. Because in order to board domestic flights, your driver's license or state-issued ID must be a Real ID, or you'll need another acceptable form of identification. So don't wait. Find out how to get your Real ID at tsa.gov/Real ID. That's tsa.gov/Real ID. Or visit your local DMV. And then you'll be cleared for takeoff.